So, gather around, children. I'm going to tell you a story. This is the story of how Jen's apartment was flooded in November 2009 in the middle of the night. I am not joking you. As a student in UCC, I was living in the Castlewhite apartments on the bank of my own lovely Lee. And the lovely Lee burst its banks and came into my apartment and destroyed my violin. All my clothes got wet and all of my notes from first semester, as in like September, October, November, were destroyed in the flood, and I had to live in a guest house for a few months while the apartments were being renovated. So that is the prelude to the lovely River Lee bursting its banks at UCC, and how this relates to the tort of negligence in the recent Supreme Court case of ESB versus UCC. So this is Law Hero. Stay tuned. Please subscribe if you already haven't done so, and like if you like this video. Don't like if you don't like this video, and follow along on Instagram at Law Hero IRL for daily stuff from me. So essentially, the Supreme Court of Ireland found that ESB was guilty of negligence in relation to the extensive flood damage done to UCC. And just to make you understand, so the source of the River Lee is in West Cork. There's a dam there, and usually the dam is regulated by the ESB as to the flow, because obviously if the flow, and I'm not very good at geography, but obviously if the flow is too powerful, for example, if there has been a lot of rainfall up at the dam, they may need to release some water. But on this evening, in Inniscarra and Carrickdrihid, there was a negligent handling of the upriver dams. So you can imagine the amount of damage that happened down the I suppose estuary where the River Lee comes out in Cork City. And unfortunately, UCC is on the banks of the River Lee, making it a spectacular campus, but extremely vulnerable to flooding were something to happen upstream, which it did in this particular November when the River Lee broke its banks. And I do remember the weeks leading up to the flood. Like I was a first year law student in UCC, and I do remember the weather was extremely bad. And I remember that night I was actually out clubbing, and I came home at 1 a.m. and I actually think my room was flooded at around 3 a.m. I think I remember people waking up. I wasn't woken up, but I did see the water on the ground when I woke up, and we all had to go outside, and it was horrible. So yeah, I'm going to talk a little bit about the judgment now before I go off on a tangent. So I'm not going to look at the High Court or the Court of Appeal judgments, but just know that the crux of the matter was that UCC alleged both negligence and nuisance against the ESB, which the ESB obviously denied. But of course, it did say if they were liable, that UCC should be liable for contributory negligence, which is a defence in tort. So when you go through, normally when you go through negligence, you start with the duty of care, and where the duty of care had left off in Ireland was the Glencar Exploration v Mayo County Council judgment, which you'll all know from your Law Hero notes. And this is the basis for establishing the duty of care, obviously, that damages must be suffered and it must be both foreseeable and not remote. So it's the foreseeability and remoteness rules. So obviously this is what UCC sought to rely on, that ESB owed them a duty of care. In its defence, the ESB relied on actually a UK Supreme Court judgment called Poole Borough Council whereby in that case the defendant had caused harm to the plaintiff, and there the defendant had failed to improve matters for the plaintiff, which they claimed they had done. And the ESB said that the law of negligence generally imposes a duty not to cause harm, rather than a duty to provide other persons with a benefit. So I think this is an interesting argument, because when we say duty of care, like, it's more protectionist rather than like antagonistic, or an obligation to do something positive. It's more of a shield rather than a sword, and I find that really interesting, and I never really thought about the duty of care like that before. Obviously there's no specific case law around the duty of care and dams, so this is quite novel. UCC said that, however, that there was an imposition of a duty of care as regarded dam in MJ Corden, which was I think a Canadian case. And UCC said it was just and reasonable to impose liability on the ESB, which was the entity engaged in what is said to be a hazardous industrial process, so that it must be obliged to take reasonable care in its operations not to cause injury or damage. So because of the nature of what the ESB was tasked to do, it's basically to protect everyone in Cork when you think about it. It's a lot of responsibility, and they're a state body, that the duty of care was implied given their monopoly in Ireland to do this. UCC also relied on an English case called Embry v. Owen, which is actually an old 1851 case, where it was observed the owner of the upper stream must not raise the water by dams, so as to make it fall with more abundance and rapidity than it would naturally do, and injure the proprietor below. And that's exactly what happened here. The court said the case law could be generically described as do no harm jurisprudence, and that the do not worsen nature approach taken in some of the dam cases represents a particular application of the do not harm approach to cases such as this. It was very, very interesting that they relied on this. They also relied on a number of US, some Supreme Court and District Court of New York cases as regards this, around flooding and duty not to harm. And I think there was also like Arkansas, Georgia, Pennsylvania, like there was an awful lot of jurisprudence relied on from other jurisdictions, because we don't have this body of case law in Ireland. So what happened was the Supreme Court found ESB liable. I think it was Frank Clark, John McMenamin, and Elizabeth Dunn. And I think it was Justice Barrett in the High Court who heard it on first instance, and they noted the finding by Justice Barrett that another management system would have reduced flooding downstream, and found the ESB was negligent in not managing the lead dam in line with that system. Commenting on Glencar, they said, "We are not sure that the use of that part of the test, to the effect that a court must determine whether it's just and equitable," and this is another limb that Glencar introduced to the test for duty of care, if it was just and equitable, which is so bloody woolly and, like, pardon the pun, but opens the floodgates. I'm gonna get abuse for that. "In all circumstances, to impose a duty of care is really of any great assistance." Oh my God, you're only recognising this now. It begs the question of how a court is to decide what is just and equitable. So yeah, the court said that ESB had a special level of control over danger. So this is Robinson v West Yorkshire Police case, and found that the case was one of a limited situation where the law imposes a duty to confer a benefit. So this is an exception to the general rule. This duty of care arises on the basis that ESB had a special and substantial level of control, ultimately a monopoly, which would enable it to prevent or reduce harm arising from a flood danger. So I mean, it is true, if you were in the ESB and you wanted to, I don't know, flood Cork and bring back Noah's Ark and go off on a rampage, you could do it, and you need to have some controls around that because you guys are the only ones who know how to operate the system. In concurring, Charlton noted that the High Court's finding of the fact that ESB had storm warnings, and I do remember that in the media at the time, the ESB knew a storm was coming and they did nothing. I remember reading that, and knew about the condition of the ground. It should have provided anti-flooding space in the reservoirs by earlier release of the water. Basically, they were too late in reacting to the weather. The judge said that if the ESB had released the water earlier, UCC and Cork may still have been flooded to some degree, and that any assessment of damages will be assessed on the differences in the two floods, which is a hypothetical argument. And actually, the other thing you need to know about UCC, like, it really is on a floodplain, and there is a basement there full of computers in the Western Gateway building, and like, you can imagine the amount of damage that was done to the IT stuff in there. So I mean, notwithstanding the fact it was a university, you know, you don't build on a floodplain normally, but I suppose you're relying on the systems, you know, ESB and whomever, to regulate the control of water. So, you know, there's not so much fault there, but I suppose in future, you know, when you're thinking of basements near rivers and IT, you would probably put them somewhere else. The dissenting judgment came from Mr. Justice O'Donnell, who said the Lee is prone to rapid flash flooding and that the flooding was not caused by ESB. He said that ESB's customers would not only bear the cost of substantial damage and increased electricity charges, but also the increased cost by the reduction in generation efficiency that would be a consequence of the measures necessary to be taken to avoid any risk of flooding, steps which would have been taken in all hydroelectric dams in this jurisdiction. He has a point there, and this is normally what happens in insurance cases, when the insurer gets slapped on the wrist, ultimately the customer bears the cost. So that is true. This would at the same time release insurers from the obligations that they unambiguously undertook. So basically he's saying here that your insurance policy should have covered this. The judge said it was difficult to explain to why the insurer should be relieved of that part of the cost of flooding claims by being able to make a claim against ESB, especially since this cannot have an impact on the calculation of the premium to their client, but would however require ESB either to absorb those claims or to insure against such an extensive liability. And again, he makes a valid point here, and I kind of tend to agree with him. What's the point in having an insurance policy and being reinsured, and all these different jurisdictions of all these different tax setups, if the bloody money isn't there when, you know, the floodgates open. And on that note, I'm gonna leave you guys go. Yeah, so this case will be added to my Law Hero Tort ebook, because this is relevant jurisprudence around the just and equitable limb of Glencar. Basically said it's not very helpful, and it's a nuanced case in that the benefit of a duty of care has been highlighted and you know, differentiated on the facts of this case, which is very, very interesting, and it's a must for your next tort exam. See you the next one. I hope you enjoyed yourself and my ramblings, and yeah, stay tuned for more.